A will is a legal document that sets out a person's wishes for the distribution of their property and assets after they die. It is a crucial part of estate planning and is governed by civil laws in many countries, including India. A will allows a person, known as the testator, to name one or more beneficiaries who will receive their property and assets after they die. The testator can also name an executor, who will be responsible for carrying out the wishes and instructions outlined in the will. The executor is responsible for gathering the testator's assets, paying off debts and taxes, and distributing the remaining property to the beneficiaries. In India, the law governing wills is the Indian Succession Act, 1925. According to the Act, a will must be in writing, signed by the testator, and witnessed by at least two people who are not beneficiaries of the will. The testator must be of sound mind and must have the capacity to understand the nature and extent of their property and the effect of making a will. A will can be revoked or amended at any time by the testator, provided they have the necessary capacity to do so. If a person dies without leaving a valid will, their property and assets will be distributed according to the rules of intestate succession under the Indian Succession Act, which sets out the order in which the deceased person's relatives are entitled to inherit. In conclusion, a will is a legal document that allows a person to specify how their property and assets should be distributed after their death. It is an important part of estate planning and is governed by civil laws in many countries, including India. What are the precautions to be taken while writing a will? Writing a will is an important process that should be approached with care and attention to detail. Here are some precautions to take while writing a will. Consult a lawyer. A will is a legal document, and it's always a good idea to seek the advice of a lawyer who specializes in estate planning. A lawyer can help you understand the legal requirements and ensure that your will is drafted properly. Be clear and specific. A will should be clear and specific about the property and assets being distributed, as well as the beneficiaries and any conditions or restrictions you want to place on the distribution. Update your will regularly. Your circumstances may change over time, so it's important to review and update your will regularly to ensure it reflects your current wishes and circumstances. Choose your executor carefully. The executor of your will is responsible for carrying out your wishes and distributing your property and assets. Choose someone you trust and who is capable of handling this responsibility. Consider tax implications. In some cases, there may be tax implications for the distribution of your property and assets. It's important to consider these implications and consult a tax professional if necessary. Keep your will in a safe place. Once your will is completed, make sure to keep it in a safe place, such as a fireproof safe or a safety deposit box. Let your executor and family members know where it is located. Avoid undue influence. It's important to ensure that your will is your own decision and that you are not being unduly influenced by someone else. In conclusion, writing a will is an important process that requires care and attention to detail. By following these precautions, you can help ensure that your will reflects your wishes and that your property and assets are distributed as you intend. Thanks for watching. Please subscribe for more videos.